Okay, hello everybody. Hope you all can hear me nice and fine. Yes, good afternoon everyone. Hope everyone can hear me. Right, so let us start with the today's lecture. Yes, everyone can hear me. Okay, good. See, the today's class, as I have already told you, right, that I will be discussing few things that have been left in the previous classes. Okay, let me open the PDF file for today. Yes. So as I have already told you that there are two topics that I will be covering, right? There will be two topics that I will be covering, topic 2 and topic 3, and that have been disintegrated into four topics, right? So the fundamental right and their evolution I have covered, fundamental right individual provisions I have covered, right to up to right to this article 23 and 24 I have covered, right? So today I will be starting with article 25, okay, 25 to 28, then 30, 31, and 29 and 30. Then I will be talking about PIL, the type of question asked and what are the things that you need to focus. And then we will talk about legal aid and service authority. Okay. So these are the topic that we will cover today. Okay. Now, let us start with the freedom of religion part. Okay. Now, what you need to study in that particular part. Okay. So that is first. Let me handle it. Okay. See, first you have to talk about the scope of the whole article, right? So if you will look at the last 5 to 10 year question, you will not find even a single question that have directly asked article 14. They always ask the question which actually clubs article 25, not 14, sorry, article 25 to 28, right? They always ask the question regarding that how far these article aims at providing a secular India, right? So always the philosophical aspect of that article is asked. Okay, so that is the one thing that you should keep in mind while studying right to freedom of religion individually. Rather, do not study individually but study them interdependently. Okay, the overall main, I will in the case law I will explain also that what are the type of question that is asked. Similarly, the key word that in these articles are religion and religious denomination. Right, now there is a very famous case, right, that provides the definition of religion or religious denomination, how a particular denomination can get the benefit of article 25. They can only if they are part of a religious denomination. Okay, now what do you mean by religious denomination? So religious denomination basically means if you satisfy three criteria, right, meaning you must have a specific name, it must be continuous from a long time, understood, and there must not be any evidence that okay, sometime this particular thing, yeah, this particular denomination was discontinued in between. Okay, similarly that have been extended to a 5 scale test whether a particular habit in a particular religion is a part of that religion or not, which enables them to get the protection of article 25 to 28. Understood? So that is also an important part that you should understand. Okay, so the key words such as religion and religious denomination. Okay, now this Sabrimala case you must have seen whether the act of women participating in Sabrimala temple was part of religion or not. That was actually in the issue in that particular case, right? And the court held that yes, it is a part of religion. Okay, and I mean there was 5 judge bench, 2 held it is a part of religion but it do not offend article 25. Others held that no, it is not a part of religious activity at all. Okay, because it have been discontinued, that particular habit of not allowing women, women of a certain age to participate in Sabrimala temple, that particular thing was discontinued for a brief period in between. So the court held, 2 of them held that okay, it is not a part of religious doctrine itself, so it will not get the protection of article 25 at all. Okay, so 4:1 the judgment came, you must be remembering, that is very important. But read the dissenting opinion of Justice Indu Malhotra, the only women judge. Okay, so that is quite an interesting part there. Okay, similarly this interrelation between other categories. Okay, so the 25 to 28 has to be read with 29 and 30. See, in the very beginning I told you that fundamental right basically tries to protect the interest of minorities a lot. Why does it do so? Because in the case of fundamental right, in the case of minority, they do not have the political power to enforce what their interest is, right? So they try to enforce it through these articles. Okay, so that is why in any constitution in the world you will see that the fundamental right are specifically provided to the minority, right? So the primary purpose of the fundamental right is to protect minorities from the rule of majority. Now please do not raise hand right now, let me complete this whole, then I will one by one I will take question that I take always. Okay, Mr. Sushant Hasbi, please. Okay. Video quality of screen is not clear. No, I think everyone else is getting the screen nicely. No. Okay, so I think there must be some problem. Okay, let me do something. Let me re-share the screen. Okay, now is it clear? Yes. Okay, sometime it happens, right? It is machine, obviously. It is supposed to sometime not perform better. Okay, good. No problem, no problem. Now it is clear. Okay, so what actually I was talking about, that in the case of article 25 to 28, you have to study those articles not individually but collectively. Okay, then focus on the keywords such as religion and religious denomination that I've already told you. Then always read these particular article with interrelation with another articles. Okay, how far secularism in India has to be promoted by these. Let me give you some case law. There actually the court have very nicely held. See, Ismail Faruqi versus Union of India. It is clear from the constitutional scheme that it guarantees equality in the matter of religion to all individual group irrespective of their faith, normal thing. Then the preamble of the constitution in particular, constitution read in particular with 25 to 28. See, it is actually connecting preamble of our constitution to article 25 to 28. Okay, see, preamble of the constitution with, emphasizes this aspect and indicate that it is in this matter that the concept of secularism embodied in the constitutional scheme as creed adopted by Indian people, right? So this particular line can also be written in the questions where the requirement of the answer is that you have to write how secularism is a part of basic structure, right? So you can answer mention this particular case law in that as well. Okay, similarly they have talked about in great detail. Similarly, in the case of this particular case, right, Acharya Jagdishanand Advaita, right, very famous case there, the religion, what do you mean by religious denomination, that I just argued just 5 minutes before, that is also mentioned here. Okay, now if you can see the whole thing, one thing is very clear in this particular case, that article 25 have relationship with article 14. Okay, so that is the interrelationship that I am talking about, right? So most of the question is always of interrelationship. Okay, so that interrelationship has to be understood by you, has to be read by you. Okay, so please keep that particular thing in mind, right? So let me read it also. See here, if one religious denomination is allowed to carry its religious practice but another religious denomination is restrained from carrying religious practice and almost similar religious practice, the same makes out a clear case of discrimination and violation of article 14, right? So you cannot discriminate against religious practice between two religions which are similar in nature. Okay, so that is the connection of article 25 to 28 with article 14, right? So that is what I was talking about. You read the interconnection basically, right? Do not simply go through the case law and read it again and again. No, read the exactly what is asked in the UPSC exam. Okay, in judiciary the structure is different. Judiciary they ask you very specific, okay, this is the particular article, give me the answer, right? So you have to write case laws and everything, but here more jurisprudential nature of the question comes. Okay, so that thing you have to keep in mind. Similarly, see this Bal Patil in the versus Union of India, they talk specifically that how the minority religion needs to be protected in a much better way. Okay, and they say that Muslims are being a minority deserves more protection than with respect to another religion. Okay, so that is something you should keep in mind. Let me read also. It is against this background of partition that time of giving final shape of constitution, it was felt necessary to allay apprehension and the fear of the minds of Muslim and other religions. Okay, Justice Dharma Adhikari very nicely have observed, right? The purpose is to protect the apprehension to the minority. In any democracy, the minority is always under threat. Okay, so that is a very philosophical argument that he is giving. Similarly, with the aim of with the above aim in the view of the framework of constitution engrafted group of article 25 to 30 in the constitution. The minorities initially recognized were based on religion on a national level. They have to given the name of minority. Similarly, article 25 to 30 at the historical background of the partition shows only to give guarantee of security to the identified minority and thus maintain integrity of the country, right? So basically they are saying that this particular fundamental right is somehow protecting the interest or the integrity of the country by giving them sort of a statement, sort of a consonance that okay, this is the right that you will get. So even if you are a minority, you need not to afraid with us. Okay, so that is something, a very interesting thing that they have provided here. Right now, one is saying that it is getting disconnected or there is a technical problem. I think, hope most of you have no technical problem, right? Because on my laptop nothing is showing, right? So I think there, I mean there is no problem at all. Okay. Now, similarly, you know, again a very philosophical line, that ideals of democratic society which was adopted, right to equality as fundamental creed, should be elimination of majority and minority. See, that is the point, that the minorities should be kept in power of majority. And how the minority can be kept in the power of majority? Because in the case of minority, they do not have political mileage to enforce their interest, so the constitution provides certain extra benefit to them. Okay, so that is the whole purpose of article 25 to 28. In fact, article 29 and 30 also, that is also the whole purpose of that, right? Then we will come to article 29 and 30. Right now, if you will look at 29 and 30, I have already discussed that in very detail, right? The relationship between 29 1, 31, 29 to 32. Now, those of you who have not attended that class, right, I think I have discussed it in lecture 1, right? So I have put it up on YouTube. Now I will not put up all the video daily on YouTube, obviously, because it takes processing and lot of things. So what I will do, that each week I will put one video. Okay, so that is how I mean 3 videos I have put it up, right? But after that, each week I will put one video. Okay, so I will suggest, if you want to study, then you continue attending these lectures. That will help you a lot. Okay, so that then again, the philosophical aspect of the article 29 and 30, never they have asked question directly from 29 and 30 individually with case law. Never they have asked. See the paper of last 15 years. They might have asked 20 years back one question. Obviously that do not count. Okay, so you have to study only the philosophical aspect and the interrelationship between them, nothing else. And the case laws that I mentioned earlier, right? So you should read that. Okay, and specifically see lecture 1. In that I have discussed that in very, very detail. Okay, the interrelationship between 29 and 30. So please read that. Now, the second topic that is multiple time the question comes is basically PIL. Now, the PIL is mentioned here, and it is mentioned as well as in the CLD portion, if you remember, Contemporary Legal Development, paper 2. Okay, now obviously you should not study separately, so you should club PIL with paper 2. Okay, I mean the topic of constitutional law with the topic of CLD. Okay, you should club both of them. Now, what are the various dimensions of PIL that you need to study? Okay, see, first is the constitutional provision, that how actually it have evolved. Okay, so you must be knowing it have evolved using unique interpretation of article 13. Okay, clear? And then obviously article 13 read with article 32. Okay, so obviously both of them has to be mentioned. Similarly, you can also learn the historical perspective of it, that how initially the locus standi rule was very important, but later the court held that okay, locus standi can be loosened. Okay, because they are a public free spirited person who want to come to the court and wants to give benefit to someone else, then what is the problem in that? Okay, so that thinking actually changed. Now, why the thinking changed? There itself it comes the philosophical aspect, because of making court too accessible. Okay, right now the courts are not accessible. Why? Because in the case of courts, 90% of the time what happens, that in the procedure and everything, people do not actually get justice, right? So the purpose of this particular article was, the purpose of the evolution of PIL was to give benefit to the individuals so that they can access to the court in a easy manner. Okay, so you have to study each and every nature of that particular PIL. Okay, and then you should understand it. Similarly, various dimensions connected to it, such as that how it is related to judicial activism. How it is related to judicial activism. Okay, what is the difference between how far both of them are connected. Okay, similarly, one more thing, what are its merits and demerits, right, and various dimensions, right? Now, what are the various dimensions you can think of, right? So you can think of actually 5 dimensions of PIL. Okay, the first dimension of PIL actually you can think of is basically environment. Second, bonded labor. Okay, now environmental jurisprudence is quite important. I will discuss one article as well. Okay, then you can think of PIL of having social evils. Okay, direction to the government, investigations, right? The court have been issuing investigation in certain particular deal just through a PIL. Okay, similarly the court have been simply granting not orders but directions that you please do these things. Okay, so that have a persuasive and moral value. Okay, so there are 5 dimensions of PIL that you should understand. Okay, now I have taken 2 articles that I have given in my de facto law.in website. Let me give you those 2 articles. This is the link I have given. So when I will share this PDF, you can take the link. CM PIL. Now if you will see this PIL and judicial activism, that is the on the website I have taken the PDF file, right? So if you will look at it, you will find that I have given the initial heading, what is this particular PIL, how it have evolved, see, I have given that as well. Similarly, I have talked about that how this interpretation have evolved. Okay, so it have started with SP Gupta case. Okay, you must be knowing it, for quite important case, right? Then the first reported case of PIL, Hussain Ara Khatun, right? So I will suggest you this again, then Bandhuwa Mukti Morcha, then judicial activism. Okay, that how PIL have helped sometime to become judicial activist judge. Okay, so that is again another important thing that you should read. Okay, so this whole PDF you should read it down. Okay, so that will cover one aspect of the PIL. Okay, good. Similarly, the second aspect, that is seldom found, right? That actually you can also study, is basically, if I am correct. Oh, I don't think this. Okay. This PIL and Environmental Protection Law of India, right? Constitutional manifestation. Again, this is one of the link. I think it cannot open. That is not opening. I suppose there is some problem. Okay, so no problem. I have given you the link. You go and look at that particular link. Okay, so that will be more than sufficient for you. Okay, so what is the content? So the content is that the environmental protection, how the PIL have been used, right? So all the MC Mehta cases, all are PIL actually. Right, so that is a new jurisprudence that have come into picture. Okay, so that you have to study in the case of PIL. Understood, everyone? Good. Now let us come to the next part. Let me see some of the questions that will give you sort of a hint that what kind of questions from PIL comes. See, what is PIL, what are the major facets, form, I have already told you, environmental, this, that, right? Then discuss the limitations. Okay, what are the limitations? You cannot identify the victim, then how actually the relief can be granted. Okay, that is a very important demerit of the PIL. Similarly, what is PIL? See, again the same question. Okay, I think retyped it. Third, locus standi is necessary for challenging administrative action, right? So this use of PIL in administrative law. Okay, see, another aspect that you can see, that I have told you also, the directions, right? So directions only happens in the case of administrative law. Okay, or investigation, sorry. Similarly, comment on the statement that PIL is not a pill against all the ills. Huh? Very interesting framing of the question by UPSC. These all are previous year paper actually, right? Or not a pill for all the ill, right? So basically they are trying, they are asking to criticize the PIL, okay? That you can come up with, okay? No, I will send you the PDF. So if you cannot read one or two cases, not to worry, I will send you the PDF, okay? Good. Similarly, examining the scope of the significance of Article 32 in context of PIL. Article 32, I told you, constitutional provision with regard to PIL, right? And the MC Mehta versus Union of India, right? Now, obviously, there is a lot of MC Mehta case, right? So in 1987, I think it was Taj Mahal case. I am not sure, yeah, you have to read that one. What is that exactly, the MC Mehta case? Similarly, PIL writ petition cannot be filed in Supreme Court under 32 of Indian Constitution only if a question concerning of enforcement of fundamental right is involved. Okay, obviously this statement is not entirely true. Okay, PIL writ petition can be filed for the purpose of enforcement of fundamental right, but the difference between normal writ petition and the PIL, that in the PIL the actual person who have been ignored or who have been discriminated against, whose fundamental right have been violated, they have not attended it. That is the only difference, right? That is the only difference. Okay, so that is the one thing that you should keep in the mind. Okay, that the PIL, the constitutional provision of PIL has to be understood in a better manner. Okay, everyone, so that is one thing you should keep in mind. Now everyone come on time. Already 20 minutes is over. Okay, so if you do not come on time, this video will get updated on YouTube after 1 week. Okay, so if you will attend daily, obviously you will get video daily, you will study daily, but if you will not attend, you will not get it. Okay, because see, on YouTube multiple video has to be uploaded, right? So I am planning that whatever I will record here, right, the same thing I will upload for the next 1 year. Okay, so that is the plan here. Okay, so you should try to attend these lectures. Okay, so that will be much more better. Okay. Now let us come to the last topic of today's discussion. Very interesting is the legal aid and legal service authority. Now this is a very generic topic, right? It is very generic topic. You cannot actually find a particular line or particular paragraph related to these generic topic. But what I will suggest that you simply understand the meaning of legal aid. Right now, the meaning of legal aid has to be understood in the terms of criticism of judiciary. Right, that why legal aid was needed. The very requirement of needing a legal aid cast apprehension on judiciary that they are not performing efficiently. Okay, so in that aspect, understand the requirement of legal aid. Okay, then read this Legal Service Authority Bare Act. Just read the Bare Act itself. Now, if you look at the Bare Act, in which functions or the aim of all the legal service authority have been given at the union level, state level, and district level. Now, beautiful lines have been written in those particular Bare Act. Okay, so simply reading that line and reproducing in the exam will suffice any question related to legal aid as well as the legal service authority. Now, I will take questions. Do not raise hand right now. I will take questions. Let me finish it. Okay, then I will take individually question. Not to worry. Now, then the philosophical aspect and the constitutional mandate of it has to be studied. Now, what is the constitutional mandate? So, what are the area in the constitution which provides for legal aid? So, one is Article 39 and DPSP specifically it provides for it, right? Then, in the case of this Article 21, also the court have said that providing effective legal representation is part and parcel of legal aid. Okay, so the legal aid, when there is a question regarding constitutional aspect of legal aid, so it has to be DPSP as well as it has to be fundamental rights. Understood, everyone? Okay, so that is the constitutional aspect of the legal aid that you should understand. Okay, now the question I could find in the last 10 years only one question actually. 5 year. The horizon of legal aid has been widened. Best still impact on totally missing. Impact is totally missing. Comma. How do you resolve this crisis which is running in life of millions of the poor people of our country over the years? Suggest some concrete measures to make it more effective and implemented. Now, this is basically trying to you have to criticize the judiciary, the effectiveness of judicial institution in our country, right? Now, if you will look at the judicial institution in our country, one thing is very clear, that is not performing well. Okay, so there was a 2-3 months back there was a frontline issue, right? The frontline, you must have read in that there was a very interesting issue regarding the whole judicial activism and the PIL and the legal aid. The whole issue was on that, right? So beautiful articles have been written there, right? So I have shared some of the PDF in that particular article in this de facto law Telegram group. Okay, so if you will scroll backward, you will find certain articles. Okay, so read that. Okay, I don't have right now that article obviously because I sent it and I forget obviously, right? But it must be there in the Telegram group. Okay, so you scroll back and you will get it. Okay, so that will be more than sufficient, right? The whole around 12-13 article was there in that particular issue of the Frontline. Okay, Frontline magazine actually. Okay, it is a publication of Hindu group. You must be knowing it, right? Quite important. Okay, so that ends our today's question. Discussion, right? Now let me give you the question for today, and then you will raise your hand, right? So write down the question for today. Question. Right? I will ask you to write this itself. Write down. PIL have brought people, court, and institution together. Comment. Now it is a very generic question. It can take multiple shape and form. Okay, you can mention with the recent jurisprudence of the PIL with respect to this giving property or this housing market. You can talk about environmental jurisprudence, how this PIL have been used for the purpose of effective implementation of certain laws. Okay, through the direction. NGT recently got a direction. Supreme Court have convened a separate green bench for the purpose of hearing PIL related to environmental cases. Okay, so everything that you can possibly think of can be mentioned. Okay, now again it will be a 20 marker question. Generally the philosophical question are always of 20 marks. Okay, so you try to write it down. Right, now I will discuss some of the answers that I got of the last paper, then I will take the questions. Okay, not to worry. First answer I got from this answer, right? Very interesting answers he have wrote actually. Do you agree with the statement that all the human rights are fundamental? And now one thing I must point out, that most of the students who are sending me answers are basically girls, right? Boys are not sending me much answers, and their girls are writing very nicely as well. That is why you will see there a lot of them are topping in this UPSC exam, right? So that is something very interesting. Okay, this was the question, that all the human rights are fundamental rights. So she have written about this very nicely. Then she have compared them, right? But obviously she have written a lot of them. 4 and 5 would suffice. See, everything she have written nicely. Then she have talked about UDHR and Part 4 DPSP, right? So some of the provision of the United, this Declaration of Human Right, that provision have been kept in the DPSP as well, right? So that is the unique part that she knew and she have written it. Okay, see how nicely she have mentioned everything. Then the interpretation of the court, that how court have used UDHR to interpret as a aid of interpretation for our fundamental right and DPSP. How nicely actually she have written it. Then uh, in the last, she have, I think, come up with the whole conclusion part, that the same thing, that the judgments have supported, right? Then one comment I have made here, that also add how our Constituent Assembly was aware of these contemporary rights while writing the constitution, right? So historical aspect, it could have been a passing mention that while writing the constitution, the formation of our Constituent Assembly was a parallel activity with the drafting of UDHR, right? So taking inspiration from it is obvious. Okay, so that line should have been mentioned, right? It would have made answer more better. Okay, so that is very good. No, I will not show the questions which are previous to previous classes. Not at all. I will only show the questions which I have asked in the previous class, right? So that is only I will do, right? So if you are submitting your answers late, I am very sorry. I will not evaluate it at all. Okay. Again, this question, I don't know who have sent it. I have taken 3 copy actually. No, first let us see this copy. Do you agree with the statement or same question, right? Now, let us see here. If we look at this particular question, this particular answer, sorry. So see, no. What is this? That this is not a one line answer, right? So how bad is structuring, right? So structuring has to improve, right? You cannot write practically no. Okay, it is not a yes or no question, right? It is an objective, it is a subjective question, right? Not an objective question. Okay, so that you cannot write. Then human rights are inherited by human being regardless of his sex. This. Okay, ठीक है, that is okay. Again, see the structuring here could have been much better. Proper heading should have been there. They have written everything in point wise. UDHR 30. No need to write this how much human rights, and again the same thing is being repeated. That indicates poor knowledge. Okay, repeating, you don't have words to write, so you're repeating the same word again and again. Okay, so please avoid that. Then the person has come to are the assault. Okay, you could have written that in the earlier part. Okay, then you could have written these things. Okay, introduction. Then in the body part you could have put it. Okay. Then yes, I will upload the good answer copy. Richika, the email ID is same, the website address defactolaw.in@gmail.com, right? You send your answer there. Right, equality, freedom, exploitation. Now what is this? You are writing the index of the constitution? Obviously no, right? So very bad actually it is. Not needed at all. You have to compare it. No. Lot of improvement needed. Whoever copies it is, lot of improvement is needed. Okay, very poor answer here. Please improve yourself. Let us come to another copy. Yes, and please write your name on the top, right, so that it will be easy for me to identify it. Okay. Do you agree with the statement all human rights are fundamental? Okay, yes, same question. Organically linked. Yes, good, very good. Yes, good intro, very good intro. In fact, I've clubbed it, everything very good. Purpose, heading है, थोड़ा सा उसको underline कर दो, heading है तो. Okay, ठीक है, very nice. Fundamental right as human, very good heading. Do not try to make figures in law of null. Maybe in law of C you can make figures, but in the fundamental right question, making figure is absurd. Okay, so in fundamental right do not make figures. Okay, again you have given the rights itself, right? You have written whatever the Indian Constitution suggests, right? So you obviously need not to write that. You have to compare it, right? Good, you have written good thing. Yes. So this particular part can be skipped or have, if not skipped, can be, shortened up. Okay. Just mention as a passing reference. Right? Ki in our part 3 of the constitution, the rights such as this, comma, comma. That's one line. Right? It is taking a lot of space. Fundamental. Okay. Again, why this line you are writing? This already have given you in the introduction part, right? So you are repeating the same concept which you have written in the introduction part. No, it means you lack content. You lack content. Yes, Gagan is saying that's your copy. Okay, Gagan. Life is a gift of nature. No, but you haven't mentioned the compared with the fundamental right that okay this is there in the UDHR, this is that we have, or in something have been given DPSP as well, the copy that I showed you first time. Okay, this Lekha, right? She is actually my law optional student, I suppose. Yes, she is, right? So she is, have been studying, I think, nicely. She have completed her syllabus and she is writing very good answer, I suppose. Okay, now let me come to another copy. Okay, so the 3 copy I have taken together, so I will only check 3 copy for today. Okay, now let me come to the question and start with the answer one by one. Okay, every day the real me have lot of questions. Yes, real me, go ahead.
Hello, sir.
Yes.
Good afternoon, sir.
Good afternoon. Some sound is coming from your side. Please switch it off. Yes.
My question is related to Article 16.
Article 16
state.
No, I
Article 16.
only ask the question which I have discussed today. That question I have already discussed. So I will suggest you to watch lecture 3 and there I have given the answers. Okay, Realme?
Can I ask right now, sir?
Can you ask?
Right now, can I ask this, sir?
No. Let us concentrate ourselves to the topic discussed today, right? So that will again, extend the definition. You do one thing. You comment on YouTube. I will reply there as well. Okay?
Okay. Thank you, sir.
Only try to ask questions today itself. What we have discussed. Yes, Mr. Brahmajot Singh, please go ahead. No.
Good afternoon, sir.
Good afternoon, Brahmajot. Please go ahead.
Sir, could you explain the difference between the writ under Article 32 and writ with the PIL again, please?
See, in the case of PIL is basically a writ petition where the victim has not been identified. Okay, so that is the primary difference between PIL and writ. PIL is necessarily a writ petition. PIL is necessarily a writ petition, but see, when that PIL judgment came, the Supreme Court said that you can come under Article 32, but there has to be a mention that it is a PIL. Okay, so that is why there was a question also that it is not exactly a writ petition under 32, but some certain add-on has to be there on that. So under Supreme Court rules, that is the add-on. Okay? Good. Yes, Avan, go ahead.
Good afternoon, sir.
Good afternoon.
Sir, my question is, what are for the legal aid question, the previous year question, it asked for suggestions to improve the situation of legal aid in India.
Yes.
So, what could be those suggestions?
Very generic suggestions, right? Use of IT, streamlining the court procedure, right? Calling of the evidence through video conferencing, right? So whatever the time that is being lapsed, that article again, that the frontline article very nicely points out some of the suggestions, right? So that you can suggest. You can also one law commission report, I am not getting the exact number of the law commission report. They have also suggested certain points, right? Change in the procedural laws. Procedural laws are too archaic, right? So multiple, these 5-6 suggestions can be mentioned. Okay, Avan?
Okay. Thank you, sir.
Thank you. Okay, so let us end today's today's lecture, and let us meet tomorrow. And whatever, one last question. Yes, Rishabh, go ahead. Last question.
Hello, sir. Sometimes, sir, we see in the reports and read in judgments that judges use interchangeably 3 terms: overreach, activism, and adventurism. Can you state what is the precise difference amongst them?
Yes, I can see. When we are talking about judicial activism, then what is the meaning of activism? Activism can be understood in 2 ways, right? First way, that you are trying to blur the line between executive and judiciary. That is the first way. Second way is that in the judiciary itself, you are trying to solve the cases or try to deliver the judgment as soon as possible. right? So activism can be understood in the positive aspect as well, right? So the three terms that you mentioned, so in negative aspect when you use, then we say sensationalism or whatever, right? But in positive aspect it is used, then we can say that okay, good thing, it is a good thing.
Okay, thank you, sir.
Okay. Yes, so let us wind up today. No, I cannot send this material before, because I make material just 5 minutes before the lecture itself. Okay, so while you all were there, I was making, okay, what are the things I should write, right? So in half an hour I make it. Okay, so I can only send it after the lecture itself. Okay, Mr. Nissan. Last 10-year paper, you go to the website de facto law. I have given there topic wise question also, year wise question also. You go and see that. Okay, so that will be sufficient. Okay, one more question I can take. Yes, Babua, please go ahead.
Good afternoon, sir.
Good afternoon. You change your name. What is this, Babua? You change your name. Yes, please.
Okay, sir, I will change it, sir.
Okay.
So, when you will reply the mail, answer of mail, sir, on mail?
You have given it?
Yeah, sir, I have given
Your answer,
all the answers of all the questions.
no problem. Your answer might not have got picked. I get around 18 to 19 mail. So I picked 2-3 one of them. You will also get picked, but don't worry. You keep writing it. Okay. At least it will help you to practice.
So will you reply on the mail?
No. Individually, I will not reply. I told you there are 80, 90, email I cannot reply on a daily basis, right? Or replying in one line will not do anything, okay? So if I reply, I has to reply comprehensively that, okay, what are the errors?
Actually, sir, the whole process go in vain, sir. Well,
that is what I am saying, that it do not go in vain. I am showing you the answers. If you go back to your answers and compare that, okay, think can improve or whatever I have told you, whether that is there in the answer. That is not in vain, right? If you feel that writing answers in vain, then I don't think you should prepare for UPSC, right?
And till when we should have to mail the answer so that it can get selected?
No, you have to mail.
Timing.
See, you just mail it. There is no timing such as, you just mail it before tonight and I will try to take it, okay?
Oh.
Yes, let us wind it up. Ramya, please ask your question tomorrow, okay? So let us wind it up. It is, I have some, people coming over to set their camera, etc., okay? And you please wind it up, okay? I will answer everyone tomorrow. Ramya, if you have any problem, you can email me. I will reply that also, okay? Good. I will have to ask the permission of the person whose copy it is. I can send that, best copy also I can send if I can, okay? I will send it. Okay, then let us meet you tomorrow. So tomorrow topic of discussion, I suppose, shall be constitutional position of president and relation with the council of minister, right? So that is the tomorrow's topic that I will discuss, okay? So that will be all for today. Thank you very much.